Good afternoon, everyone. My name is John Ferrante. I'm with NERCA, N-E-R-C-A. Thanks for getting on our webinar this afternoon. We have a good presentation. I think everyone should know who Trent Cotney is at this point from Cotney Construction Law. He's got a great presentation for us today on the OSHA inspection and citation process. Very timely with the new fine amounts coming out that are updated annually by OSHA. So hopefully this keeps everyone clear of those. A little housekeeping. We are recording this webinar, so if anybody wants a copy after it's over to review or pass along to someone else, we'll send out a link to that. Also, if you have questions during the presentation, there's a little questions box or a chat box. Feel free to punch it in there, and I can throw it out to Trent if it's relevant for what he's talking about, or otherwise we'll hold it to the end and he can field them then. So with that, I'll let Trent take it away.
Great, thank you, John. And it's always a pleasure to speak to you guys. OSHA is something that we deal with on a daily basis all over the U.S. And for the last 21 years or so, I've done a significant amount of OSHA work. It is something that's always very interesting to me because there is what you see in the books and then there's what happens in real life. And what I like to do in all my seminars is, obviously I give you the legal, but what I try to do is I try to combine the real world aspect of it. For those of you who don't know, my grandfather was a roofer. I came up in construction, so I'm not your typical lawyer. And I recognize that what's really useful to you is things that you can take home after this presentation and make changes to your existing policies and procedures. The goal of any seminar really should be to help you issue spot, so that at the end of the day, hopefully I can help you avoid a fine or figure out some better ways to go about doing things. And that's going to be kind of the overarching theme today as we talk about stuff. Obviously, I'm very passionate about safety. It's something that I think is very important. But I'm also passionate about understanding what your rights are and understanding how to defend against OSHA if they come to your job site. So with that, we'll go ahead and get started here. Let me see if I can move this forward. Sorry, I'm having some technical difficulties. Well, there we go. Oh, sorry. Hopefully Anita is on this call and she will help me get this right, who is our marketing director. While we are waiting on that, let me go ahead and just start the talking about sort of the process itself. And one of the things that is critical to understanding is, regardless of, there we go. I apologize for that. One of the things that's critical to understanding is making sure that you take the time to prepare in advance. Dealing with OSHA really requires excellent documentation. So regardless of what you do in construction, the party with the best paper wins the day, okay? What do I mean by that? By paper, I mean electronic. So it doesn't matter. Think about everything that you do in roofing. From a legal standpoint, it doesn't matter whether it's a wage and hour issue, it doesn't matter whether it's immigration, it doesn't matter whether you got a lien claim or a collection case or you're defending against a construction defect. It's paper. If you have the capability of making sure that you have the documentation, the emails, the change orders, the lien releases, whatever it is that you need to prove your case, and the other side doesn't have that, you're going to be successful. So I'll give you a great example. So I am primarily a litigator, meaning I go to court and I also review construction contracts, but I've been asked by AAA, the Arbitration Association, to serve as an arbitrator in construction cases because of my background. And when I'm serving as an arbitrator, one of the things that I look at is paper. I want to know whether or not one side can show me the documentation that proves their point. Just because they said they did something doesn't necessarily ring 100% true to me. And that's because I understand how construction projects work. So one of the things that you need to keep in mind is that if you want to defend against OSHA cases, you've got to make sure that you've got good documents. Not that you just have good documents, but they're organized and that you can put your hands on them timely. I'll give you a classic example of training as well. My father, who is incredibly patient, he taught me how to drive a long time ago. And we grew up, we had a lumber yard and we had a hardware store that serviced contractors. And in the back, there was a big parking lot. So he'd take me there and, you know, I would do 3-point turns and I would do parallel parking and I'd do those types of things. And at the end of me doing all those things, he said, son, he always referred to me as son or boy. That was pretty much it. And he said, son, what I want to do is I want to pretend I'm a police officer and I want to pull you over. And the reason I want to do that is I want you to show me how you're going to respond. You know, show me your driver's license, show me your insurance, show me your registration. And at the time, you know, I was a dumb, you know what kid, and I didn't really understand why my dad was doing that. But looking back, I know exactly why he did that. He did that because he didn't want me to do something stupid. You know, he wanted me to understand how I needed to deal with the government, how I needed to deal with the police. You should have the same thing in mind when you're talking to your supervisors and your employees. You should take the fear and the anxiety out of an OSHA inspection ahead of time so that they understand what to do, what their rights are, and what they should not do. And we're going to talk about that in more detail, okay? The people out in the field are the key to what you're doing. It's not the people necessarily that are on this phone call. It's the superintendent, the crew leader, the foreman, whoever is in charge of that job site. Those are the people that need to understand what their rights are, what the SOP is, the standard operating procedure for an OSHA inspection. You need to have these things in place because if you do that, then if OSHA shows up to your job site, everyone knows exactly what to do and how to go about doing it. So let's see if I can get this thing to work here. That stopped again. One of the things that I really recommend is documentation, okay? You need to make sure that you have, there we go. You need to make sure that you have got the critical documentation in place and on the job site if needed, because what happens is at the inspection process, it always starts off with an officer coming up and saying, hey, I was just driving by. Okay, I was just driving by and I saw that there were, you know, 4 people on a roof without fall protection or that the ladder wasn't tied off. What that does is that puts them in a box, okay? And if they don't tell you why they are there, the first thing that you need to do when the COSHO shows up, and I use the term COSHO, that's the investigator, the compliance officer. When they show up, you need to ask them, why are you here? Okay, and what that does is that confines their investigation to the reason they are there. If they are there for the purpose of inspecting your fall protection, that is why they are there. They don't have the capability to go in and look at what's going on the inside of the building. They don't have the capability to start going through your home office, all of those types of things, okay? So anytime that you're dealing with OSHA, there's a couple of things to remember. One is you always want to be civil. Okay, we've had several roofing contractors that have decided that they didn't like the government and they wanted to get in fights with it, and that's fine. Okay, I hear you. I don't particularly like the government myself. But that being said, you always be civil and you're always respectful. And then by doing that, you ensure that you are being cooperative, okay? Another thing to remember is you always tell the truth, and you're going to hear that throughout this presentation. It doesn't matter what the facts are. It doesn't matter how bad things may look in your mind. Always, always, always tell the truth, okay? Never hide anything, never do anything, because OSHA, and if you are in a state that has federal OSHA, there are 24 states that have federal OSHA, 26 state plans. If it is a federal state, then an OSHA agent is a federal agent. And all you have to do is watch the news to figure out what happens if you lie to a federal agent, okay? You don't want an obstruction of justice charge. You don't want to end up with anything like that. And we've been in situations where roofing contractors have faced that. They have not given up documents. They've not been cooperative. So it's very important. One of the things we always tell our customers is, look, I don't care what the facts are. I can work with the facts, but if you're lying, it's going to be problematic. So Don't change things just to make it look good. It is what it is, and we can deal with it. One of the things, if you are in, let's say you're a union contractor, okay, you can bring the union rep in to the opening discussion to talk about the alleged hazards and the limits of OSHA's investigation. You don't want to bar entrance or obstruct an officer's ability to review photographs or collect data. And one of the things I get asked a lot is, well, Trent, can I refuse them to come on a job site? You can. You can absolutely refuse them to come. You could say, no, you can't get access to this job site. The problem is that they will turn around, they will go get a warrant, and they will be very upset. Okay. I can tell you that in the time that I've been doing it, I can only think of one situation where before we got involved, a roofing contractor told an OSHA inspector to pound sand, and they went and they got a warrant, and it did not end up very well for them. And my suggestion is, I would not do that. Let's put it that way, is I would not refuse access. The only instance where I could ever see refusing access is if, if you've got a meth lab behind you, you can consider that, but recognize there's going to be a lot of scrutiny on you at that point. So think about that hard before you go through that process. Interviews are critical when you get on that job site. One of the things that OSHA is going to want to do at the very beginning of any inspection, and generally what I always tell customers is the best time to get help is before the citation is issued, okay? They're going to want to do on-site interviews. When they do interviews, keep in mind that there are some rights that you need to understand, okay? Please listen to this. This is important, okay? If you are a supervisor, if you are a director, an officer of your corporation, okay, if you are a superintendent, okay, sometimes if you are a crew leader, you do not have to speak to OSHA unless a member of management and management's counsel is present, okay? The difference between someone speaking to OSHA without counsel present and with counsel present is very different. And the reason is because by the time the supervisor or the director or the officer or the owner has had the opportunity to consult with counsel, to be prepared, to have their memory refreshed about their safety training, their testimony tends to be more truthful because they remember more and they understand what OSHA is looking for. Does that make sense? Does everybody follow me what I'm saying there? So let me go over that again just to make sure, because this is a critical point. Unlike criminal actions where you get a Miranda warning, where they come in and they say you got the right to remain silent, so on and so forth, OSHA doesn't have to do that. Okay, OSHA does not have to tell you what your rights are, even though you may be criminally prosecuted. I was on social media earlier today, and I heard, was reading some of the news releases. There was a roofing contractor that was just prosecuted because of an OSHA case. But they don't have to tell you that you have the right to counsel, okay? So if you are a supervisor, an officer, a director, an owner, you do not have to interview with OSHA until a member of management and or the counsel is present, okay? And oftentimes I get asked, we get involved a lot on the back end, and we interface with OSHA, and OSHA will ask us, they'll say, hey, we'd like you to come back out to the job site and we'll do the interview there. And my response is, no, why don't we come to your office? You can come to our office. I don't want OSHA back on any job site. I know they're doing a job, but I'm also doing a job, and that's to protect the customer. So I would prefer to do that off campus, and we'll set up a convenient time. Again, I'm not preventing anything from happening. I'm working with them. I'm getting them everything they need as quickly as possible. But it's about being proactive, okay? Because I could tell you what happens. Here's what happens is your superintendent is scared. They're scared for their job, okay? Think about that, okay? They got OSHA on their job site. They realize they screwed up immediately because the guys didn't have harnesses on or whatever it might be. And they're scared, so they say stupid stuff. And it's very difficult for us to deal with it after the fact, because here's what happens. Okay, we live in an age of everything electronic, right? Think about it. Everything is electronic. We send emails, we send text, We communicate via social media, communicate over the internet. We're having a webinar right now. 10 years ago, this never would have been possible, maybe 15. But today, in 2020, OSHA will pull out the old metal clipboard and handwrite a witness statement, okay? And the witness statement is given to the witness, and I guarantee you there's nothing great on there. It's always, the employer never trained me. I don't know what silica is, I don't know what the swing radius is. I was never told anything, whatever, okay? And then they sign it, okay? They sign it, and that is a sworn statement. That is admitted into evidence if you decide to contest the citation. And it's very difficult to get around it, okay? There are ways, and we can talk about it later in the seminar, but keep in mind, you do not have to sign a written witness statement, okay? What I always tell witnesses is, it's up to you, only sign a written witness statement if it 100% tells the story and it 100% tells the truth, okay? Not just part of the story, the whole story. If it does not accurately reflect everything that happened on that job site and you don't feel comfortable signing it, you do not have to sign it, okay? A lot of people don't realize that. You do not have to sign a written witness statement. What happens if you don't sign it? Well, if you don't sign it, OSHA will say, okay, I'm going to read this to you. You just tell me if it's correct or not. Okay, then that will bind you to whatever is in that written witness statement. And what I always tell when I'm preparing management or supervisors, what I tell them is I say, look, unless it's 100% what you want to say, just say, look, I stand by what I said. I'm not going to say anything more. That's it. It is what it is. Okay. Now let's talk a little bit about employee rights. Okay, crew. This is non-supervisory personnel, crew, labor. Okay, obviously you can't be in a situation where you're strong arming them. Okay, you want to be very careful. You don't want to tell them, look, don't talk to OSHA, don't cooperate, don't say anything, don't do anything. Because if you do that, you could face a potential whistleblower protection act violation under the Department of Labor. Okay, you don't want to do that. When I do train crew, and we've done both Spanish and English training, is I say the same exact things that I've said here. As I say, always tell the truth. It doesn't matter what any member of management says. It doesn't matter what I say. Tell the truth, exactly what happened, how it happened. It is what it is. Don't feel like you have to make up something. You'll never be strong armed in that event. But if you are asked to sign something, make sure that what you're signing is truthful. If it's not truthful, then don't sign it. Okay, and I try to avoid strong arming because I don't want a situation where you've got a disgruntled former employee that is now claiming that it's a whistleblower type thing. You violated their ability to it's basically retaliation for a safety violation. Okay, so let's move on to the next slide. The questions. This is one of the things I talked about. I gave you the example of my father sort of training me on how to drive. What you want to do is you want to make sure that your superintendents and your crew understand what kind of questions are going to be asked. And this is important, okay? OSHA will normally ask a series of initial questions that deal with your training, okay? They're going to want to know, tell me about your toolbox talks, okay? We all do toolbox talks. We do toolbox talks here in this office, and we're a law firm, okay? So they're going to want to know, did you have fall training, fall protection training, PPE, how to properly tie up a ladder, hydration, dealing with cold temperatures, dealing with hot and humid temperatures, confined spaces, so on and so forth. Whatever the specific potential violation is, they're going to ask training questions about that. So what I always recommend is keep a copy of your safety manual in your truck. In every single truck, make sure it's current. If you have Spanish speaking only employees, have a Spanish manual and have it present in your trucks. Make sure it's the current version. We recommend taking a look at your safety manual every 6 months, if not every year. If you're in certain states, those changes tend to be a little bit more aggressive. So it's worth updating it. During this administration, there hasn't been as much regulation. In the previous administration, there was a new OSHA reg every 2 months. It was a constant moving target. So recognize that it is a living, breathing document, and you do need to update it. In addition to very specific training questions, you want to make sure that your people remember all the training that they've had. So if they have an OSHA 10, wouldn't it be nice to tell the OSHA investigator that you've got a 10, that you got a 30, that you've got the HAZWOPER training, that that you've got a 501, that you got whatever you need for purposes of being able to show that you have safety credentials. They're then going to get into the facts, and they're going to want to know specific knowledge of what happened. So a lot of times where we see witnesses make a mistake is they assume they saw something because they were told something by somebody else. Okay, that's not good evidence. But if you write that in a witness statement, yeah, I saw that so-and-so fell. Okay, if you didn't see him fall, you shouldn't put that in a statement. You shouldn't say that to OSHA. You should only say what you know. Okay, don't speculate, don't guess, don't do any of that stuff. Okay, one of the things that you should also keep in mind is OSHA loves to ask crew people to demonstrate, show me how to put on a harness. Okay, show me how to properly tie off a ladder. Don't ever do that. Okay, don't do that. You're not required to do that. It's the equivalent of entrapment. Okay, they do that because they love being able to catch crew that haven't been properly trained. That's great evidence of that. So avoid doing that if that is requested. What I always do is again, I try to be very civil and respectful, and I've had plenty of disagreements with area directors and assistant area directors. And what I say is I say respectfully, constitutional rights allow us to have counsel present, or whatever the issue might be. You're infringing on those rights. For the record, I'm objecting to this, just so you understand that. Okay. And normally the investigators that are out there, we've had a lot of investigators that have zero construction background whatsoever, and they will stop at that point and contact their area director, and we'll get things cleared up. It's about trying to work with them. Okay. I don't like being adversarial. I'm only adversarial if I have to be, but I'm also not going to get run over. And that's the thing to remember, is you've got to be able to understand what your rights are and what they're not. Okay. Again, always tell the truth when you're speaking to OSHA. Don't ever lie. Okay. Tell it succinctly. Don't, we've got some people, I've got some friends of mine that I can't get them to shut up. I could basically, they have a conversation to themselves. Don't do that. Okay. It's if will the sun come up tomorrow? The answer is maybe. It's come up for the last 50 million years, whatever it is. I don't know if it's going to come up tomorrow. Okay. Who is the president? It's President Trump. That's it. You don't go into, your feelings on politics or anything else. You just say what's asked of you, and you don't say anything more. Okay. Be cooperative, but there's no reason to expand upon what the answer to the question is. The closing process is where a lot of times after they have gone through the initial interviews, they will do a walk-around inspection. And the walk-around inspection is where OSHA will say, okay, look, I'm out here for this reason. They show you their badge, and they will proceed to walk around the job site to see what else they see. Okay. Whoever is on that job site needs to have a standard operating procedure when OSHA shows up to the job. So I'm trying to signal to you when things are really important. Everything's important, but this is another thing that's really important. Okay, after the seminar is done, make sure that you have an SOP for job site inspections. So how does that SOP, what does it look like? Okay, whoever's running that job needs to understand, as soon as OSHA shows up to a job site, step one is call management or call the safety director. Okay, see if they can get out there, see if OSHA will wait to conduct its inspection until somebody from management or the safety director gets out there. Okay, because it's the people that are on this call that have a clear understanding of not just the safety aspect, but the business aspect and the liability aspect. Okay. Oftentimes we've been successful in having OSHA wait an hour or 2 hours. If there's some immediate threat, sometimes that's not going to work, but it's worth asking. Okay. The second step is, if they are conducting a walk-around inspection, you want to be their shadow. Okay. Everything that they take a photo of, you want a photo of. Giving me job site photos after the job is complete doesn't help me. Okay, a lot of times I will look at a construction site and I will realize that because of other items that are out there, or because of a truck bed or whatever it might not be a 6-foot fall. And that sounds silly, but stuff like that helps. It helps in the defense. So real world actual photos or videos, whatever they are taking, you want to take. Send those photographs to your lawyer. If you send them to your lawyer, they become the equivalent of attorney-client privileged information, so that your lawyer has the capability of using them and figuring out what's going on, okay? If they ask questions of your supervisor, okay, your supervisor again needs to say, I don't want to be interviewed at this time. You know, I'm not going to be engaged in an interview. I am asserting my right to have a member of management and counsel present, but I can answer logistical questions to get you around this job site. I want to be helpful and I want to be cooperative. I just can't be interviewed at this time. It's our company policy. Okay, does that make sense? And if you do that, again, you're being civil and respectful, but you're not going to get in a situation. A lot of times they're your best buddies. They'll come up and be like, so, I don't think there's going to be any real big issue here. I just saw, 5 people on an 812 dangling off the roof. It's not going to be a big problem at all for you. But, tell me, were you guys ever trained on this stuff? Did you, they'll try to be your best buddy, and then they'll turn around and you'll get hit with that, $125,000, $130,000 willful fine. So, be on guard. Make sure that the military term is stay frosty. Okay, you want to make sure that you understand that every question OSHA is asking, they're asking it for a reason. The third step in your SOP is after the walk-around inspection has occurred, and you will then either have a closing conference there on site, or you will have a closing conference at a later point. So let's talk about if it happens there on site. What will happen is OSHA will come up to your superintendent or whoever it is, and they will say, look, here's what I found. Okay, I found this ladder wasn't tied off. Your safety monitor was down at the truck drinking a beer. This rope is frayed, so on and so forth. I got to take this to my assistant area director. You can anticipate getting some fines. You'll get a nice manila envelope with all this stuff in it in a few weeks. Have a nice day. The closing conference is an opportunity to listen. Do not argue. Do not open your mouth. Do not do anything to argue with them. It's not the time to advocate. It's not the time to make admissions. Remember, anything that you say will be used against you. Okay. We had one that just wrapped up a few weeks ago. I believe this was out in, where was this? This was, I think, in Vermont. We had one that resolved where the roofing contractor at the closing conference admitted that he hadn't done any safety training in the last year. Okay, that's stupid. Don't do that. Okay, it is what it is. But when I started asking the guy questions, what he didn't know is that his insurance company came out and they did some safety training. So I said, guess what, man? That's safety training. Why did you do that? And he's like, I don't know, I got scared. Okay, well, don't say anything. Just recognize it's your time to listen. You're not going to necessarily change their mind at the closing conference. Now, one of the things that we do, though, is in between the time the closing conference occurs and the time that you get the citations, a lot of times if you've got really good information, you can get it in front of the assistant area director and they'll consider it. So let me give you some examples. I told you about witness interviews, right? So if you've got that written witness interview, and I always ask for a copy of it. Can I have a copy of that written witness interview? Okay, you're really not entitled to it from an employee standpoint. You should be entitled to it if it's a manager or superintendent. So if they end up signing one of these written witness statements and you got a copy, and it's clear that they missed a bunch of safety training or they didn't see it or you're getting a different story, have your person sign another affidavit, another sworn statement, okay? And you want to do that contemporaneously with what's going on. And the reason you want to do that is I know firsthand how difficult it is to find workers in Guatemala. Okay, we had a crew that was from Guatemala that as soon as we got hired, I reached out to interview them. They were gone. And all we had was their written witness statements. And we hired private investigators. We hired they were ex-special forces to go down. I could not find them. I couldn't find them. So get those statements while you can, because that is contemporaneous and it may contradict what they said in their statement. And we've had situations where witnesses felt intimidated or they put stuff down or they signed things because they were scared or whatever it might be. I'm not saying that happens all the time, I'm just saying it's a possibility, so it's good to have that version of what happened. Okay, again, that's all preparation in anticipation of litigation, so there's the opportunity to potentially make that attorney work product or attorney-client privilege if you send it to your lawyer. That is a strategy that has worked out well to help defeat bad statements on written witness statements. Those kinds of things, if we get them and it looks like there's a different story, I like getting that in front of the assistant area director before the citations go out, because I want to show them our side. You know, they're trying to do a job. Okay, they're trying to do a job, and we're on the other side of that, but we're also trying to be helpful. Okay, every penny that you spend on safety is a penny well spent. Okay, you know, I personally have an OSHA 10, an OSHA 30, the HAZWOPER 24, any safety training I can get, I take it. I encourage everybody out there do the same thing. Okay, and everybody that is on this call, every roofing contractor that is out there wants their employees to go home safe every night. That should be OSHA's mission. Okay, and that is always our mission. The problem is that sometimes it doesn't always end up that way. And a lot of times there are reasonable people out there where you can have reasonable conversations and you can actually make some headway on, you know, and I think we've had some respectful rapport as adversaries in the past, and I think that's a good way to kind of put your best foot forward. Before we get to the citation process, I do want to talk a little bit about documentation. I mentioned at the beginning of the party with the best paper wins the day. So I talked about your safety manual, right? Your safety manual, here's the biggest thing that I see with roofing contractors. Okay, they have a beautiful safety manual. Okay, it's 4-color, it's spiral bound, it's even got one of those clear plastic sheets at the beginning, and it sits up on the shelf. Okay, but you don't have a culture of safety. That's a key word that OSHA is constantly looking for. You want a culture of safety. Okay, so if you don't drill that down into the people that are on the roof, then that safety manual is useless. So you want to make sure, one, that you, like I said, you got bilingual. If you've got whatever, if you have a Albanian crew, guess what? There needs to be an Albanian, okay, or whatever the language is. You know, you got to make sure that they can understand your safety materials. Have sign-off sheets for your employees. Every employee should sign off that they read, understood, that they sleep with it at night, all that kind of stuff. And you need to have those employee sign-off sheets in their employee files. Safety manuals, I mentioned the need to update. Okay, how many of you have the new silica standard in there if you're mixing mortar or cutting tile? Okay, should be in there. How many of you, NERCA, there's a lot of recreational states under NERCA's umbrella. How many of you have signs of impairment for marijuana? Okay, one of the biggest, I was just at IRE, everywhere I went, I got questions about marijuana and what do we do with it? Okay, that's a great seminar. Maybe that'll be the next webinar. You need to make sure that there are how to deal with signs of impairment in your safety manual. You need to do a toolbox talk on that. So as the law changes and as the law progresses, you need to change as well, because OSHA will be targeting that. Toolbox talks. Best time to do toolbox talks for me is payday, because I know people are going to pay attention if I got a check dangling over their head. Sign-off sheets. Okay, it doesn't count unless they signed off on it. If they signed off on it, you want to keep a copy in everybody's file. Again, it's about not panicking when OSHA shows up. It's about being prepared. Preparedness gets rid of anxiety. Okay. Safety training. I'm a big believer in third-party safety training. You can get a variety of third parties out there. Your insurance companies will do it occasionally. NERCA offers some great safety training. Again, any penny you spend is a penny well spent. Audits, safety audits. Okay, you should audit your equipment daily. If there is a frayed rope, do not throw it in the truck. Don't throw it in a bucket on the job site. If it is there, OSHA will cite you. They will assume you are using it. Throw it out. Okay. Make sure that you're constantly, if you've got a deployed harness, take it out of service, fix it. I've had that happen. I've had people walking around with harnesses that have previously been deployed. It's ridiculous. I mean, I had God, if I could just show you the picture of this, the guy used ropes to tie himself off, like basically had himself in a noose. Wasn't even a harness. It's just the craziest stuff I've seen. Don't do that. Do equipment checks, but also do safety audits. So if you are a larger company and you got a safety director, And even if you don't have a safety director, if you're a member of management, drive out to your job site every once in a while unannounced, okay? Unannounced, and check the safety. If you see safety problems, identify them, write them up, okay? The biggest issue that I see with safety manuals is, yeah, they're brilliant. The disciplinary policy is great, but I don't see enforcement of the disciplinary policy. And the reason is let me ask you guys out there, okay? If your best producer, your best crew leader, okay, we all know how hard it is to find skilled labor right now, okay? If you go out there and you see he doesn't have fall protection on, are you going to punish him? Are you going to fire him? Probably not, okay, because you can't find anybody else. And I recognize the reality of that. But if you've got a disciplinary policy that you are not, disciplining employees uniformly, then that will come back to bite you. OSHA will look at that. They will ask for the last 3 years of disciplinary history. They want to see write-ups. They want to see fines. They want to see suspensions, terminations. Whatever your policy is, you need to make sure that you can abide by it. If it is too strict, usually I see escalation where it's oral, written, suspension, termination, or you can go up depending on gravity. If you can't abide by whatever your policy is, think about redoing it. Okay. The thing is consistency. You must be consistent. It doesn't matter if it's your Uncle Joe, your best producer, or the drug addict you just hired off the street. Okay. It's got to be the same one way or the other. Let me talk a little bit about, in the audit process itself, one of the questions I get is, Trent, it's great that you say to do this, but isn't that evidence that I'm not good at safety if I go out and I write somebody up? Yeah, it is. It's absolute evidence that you're not good at safety. But if you correct that safety, then that's great evidence that you have a culture of safety. Okay, so the key is if you find a safety violation, you don't just discipline, you retrain. Okay, I'm signaling this is important. You retrain. We talked about documentation. What do you need? Retraining document on how to properly put on a harness. Who attended? This person, this person, this person. This is what we discussed. Everybody signs off. Great. Okay, so what that shows OSHA is that not only are you actively trying to find disciplinary problems, but you are retraining. Okay, it can't just be the stick. You got to offer the carrot. So a lot of times I see things like safety bingo or gift cards for number of days safe or whatever it might be. Unions do a great job in advocating safety. There's a lot of different things out there that can promote safety, so it's not just about discipline. But consider that. That's something that I think is critical is to retrain and have documentation to show that you retrain. If you have a serious injury or a fatality, God forbid, unfortunately, we did 46 fatality defenses last year, 46. And look, my job is to always remain calm, cool, and collected. It's tough even for me. I've been called out to job sites within a couple of hours of it happening. And it's never something that you want to experience. If you have the capability to show that, you have a safe environment, that you have given every opportunity for people to train, then from an OSHA standpoint, that's one of the key things that we're looking for. We'll talk about the main defense, which is unpreventable employee misconduct. Okay, that's one of the key elements of that. So just remember that. Anybody have any questions on that before we move on to citation process? I know I'm throwing a lot at you, but I love this stuff, so I'm just going to keep talking. All right. So here's what happens. Okay, you've gone through the investigation, right? OSHA's come out to your job site. They've become best buddies with you. They've told you everything is going to be okay, and then all of a sudden you get the manila envelope. The manila envelope business is kept alive solely by OSHA. We have a collection of manila envelopes in our office, and I started keeping them just as a joke because we've gotten so many of them. But you will get this manila envelope, and in it will be a citation. Excuse me. The citation will say, here's what it is. It usually breaks it out in various citation 1, citation 2. There may be item 1, item 2. It will tell you a little bit about the facts, what the issue is. It will have the Code of Federal Regulations site that you violated. It will have the dollar amount associated with it, and it will have the classification. Okay, it will say This is a, other than serious, a serious, a repeat, or a willful. Okay. It will also say in that packet of wonderful material that you have to post it in a conspicuous place, usually in the kitchen or someplace where people have access to it. It will talk about your right to do an informal conference. Okay. It will tell you that you have 15 business days from the date of receipt to do an informal conference. Okay. So we talked about SOPs on job site OSHA inspections, right? We talked about the first thing is call management. The second thing is whatever they ask, you take notes on. Whatever they take photos of, you take photos on. Keep in mind, your SOP needs to be very vague and can't say anything bad about OSHA because it could be discoverable. So think about that. Don't say, screw OSHA, whatever. Don't do that. Okay, I've seen that before. Don't do that. But the idea is you create the processes and procedures that include everything from the walk-around inspection to the closing conference. This is the next stage. Okay, once you get to the citation, things start getting a little more serious. So first thing that you need to do when you get a citation is you need to call the area office, the local area office, and you need to confirm with them. Usually I do it via email and writing. What is the date that you have for my deadline to contest the citation? Okay, I'll say that again. What date do you have for me to contest this citation? Okay, and the reason you want to do that is because you get the packet of materials and it says you got 15 business days. Well, first off, it's hard to figure out when you received it, when you should have received it. The date they have may be different than the date you have. Don't rely on what they tell you on the phone. Okay, we've had receptionists pick up the phone or the office staff pick up the phone. It's like, oh yeah, get to it. Just get to it when you can. You got a couple of weeks. You're good. Okay, no, you're not good. Okay, what we do is we send an email and we say, it's our understanding that this is the notice of contest date. It is, February 24th. If this is incorrect, notify us immediately. We look forward to working with you. Have a nice day. Okay, that way you've got something in writing. Ideally, you get confirmation from them and you ask them via email, what is the deadline to contest this citation? Okay. Next thing that you want to do is you want to think about the informal conference. Generally, we recommend having an informal conference. The informal conference is an opportunity for you to reach out and try to settle the case. Okay. For those of you that have been involved in litigation, God bless you. Mediation is something that happens a lot of times when you're in litigation. Mediation is not an informal conference. Okay, mediation is confidential. Nothing will be used against you there. If you don't settle there, you just go back to your case or whatever. If you do settle, great, everybody signs it. An informal conference is not confidential. It's not confidential. So anything you say in an informal conference will be used against you. I have literally kicked contractors under the table to get them to shut up. Okay, understand that whatever you say there, it will be used against you potentially. Okay, that being said, an informal conference is an opportunity for you to come in to meet with either the assistant area director or the area director, depending on where you're at and the gravity of the case, to discuss your case, to put your best foot forward, to find out facts and information. A lot of times I'll go in and I play dumb and I'll say, okay, well, show me the photos, show me what you got. They lay their cards out on the table. They are not required to disclose their case file. Okay, they don't have to do it. It's an active investigation. So even if you send out the Freedom of Information Act, the equivalent of a public records request, you're not going to get it until after the investigation concludes. So a lot of times I say, okay, well, show me why you think this person wasn't doing what they're doing. And they'll show me the photo and be like, yep, that's okay. I got you now. Okay. And I guarantee you that whatever your guy in the field is telling you, it's not 100% the truth. Okay. We had I had a safety monitor that I interviewed, and he swore to me that he was on the job site 100% of the time, that he was watching everything 100% of the time. Sure enough, that photo showed up where he was talking on a cell phone looking away from the job site. So it happens, employees want to protect themselves. They're not going to be honest with you. So don't assume that everything you're being told is the truth, and don't be surprised by stuff that you see. Okay, the key is it's a poker game. You want to make sure that you're not flustered by whatever you see. You look at it, is what it is. You blow it off, you move on to the next thing. Oftentimes when we are at informal conferences, it is the chance for you to put your foot, your best foot forward. You show up with binders, okay? You show up with big binders full of stuff, all your safety training. And remember, I talked about keeping your documentation organized. So you want your safety manual under tab 1. You want your toolbox talks for the last few years, your disciplinary action. You want all your third-party safety training, your OSHA 10 certifications, everything, it needs to be color-coded, tabbed, beautiful binders full of stuff. And what that does is it does a couple things. One, it shows you care about safety, okay? And that's important. Second thing is it shows you're organized and it's impressive. You show up with 3 binders full of safety documentation showing everything that you've done, then the investigator and the assistant area director is going, oh God, this might not be a slam dunk for us. We may have to work on this because it sounds like this employee just didn't follow what they were supposed to follow. So that's something that I think is important for you as you kind of move forward. Keep in mind that there are a variety of parameters that OSHA has at the informal level, okay? Usually they will get rid of a certain amount of the fine, okay? A certain percentage of the fine. The dollars aren't important, okay? That's a tough thing for any contractor to hear. The dollars aren't what's important. It's the citation, okay? Why am I saying that? You're probably thinking, Trent, you must be lightheaded because you haven't eaten lunch yet. Why are you telling me this? I'm telling you this because if you get a B13 or a B10 or a B1 or a fall protection violation and it's $5,000 or it's, they've reduced it from the standard 12 or 13,000 down to 5 or 6 or whatever it might be, and you stroke a check, okay? What do you think OSHA is going to do? They're going to come back out to your job site 6 months or a year and find out that, hey, you got the same problem. I talked to an assistant area director a couple of years ago, and he said, Trent, I can go out to any job site. You put me on that job site, I don't care who it is, I'll find a safety violation. And I believe him. I believe him. If you're out there long enough with a camera, you'll find something wrong. Okay, so you need to focus on the citations. If it is something that is easily correctable, like failure to tie off a ladder, shame on you. Okay, shame on you if you can't tie off a damn ladder. If it is a B13, B10 failure to have fall protection, that's a little bit more difficult. Okay, failure to tie off, especially unhooking to get to a ladder. It's those kinds of things that even though you have 100% tie off policy, your workers in the field aren't going to follow it 100%. Okay, I'm just being honest with you. I think most of you would probably agree with that. It doesn't matter how you train or what you do, they're going to end up doing their own thing sometimes. So focus on the nature of the citation. And oftentimes we've been successful in getting the citation changed to something that's not as bad, something that's more strict. Okay, a great example is if you've got a B13 residential fall protection violation and you change it to failure to wear a life vest. I'm being ridiculous there, but you get the idea. You're never going to get another life vest violation again unless you're doing, maritime roofing or whatever, But think about that. It is not the dollar amount that is important. It is the citation, okay? And the likelihood that you will get hit with a repeat. Because keep in mind, they get you light on the first one. The second one, you start getting into that big dollar range, okay? Max on a repeat can be up in the 100,000 plus range. We just saw with the inflation schedule adjusting in January, we're up close to 130 now. So that is crazy. It's crazy to me to think about that. And obviously there are mitigating factors that cut against some of that stuff, but watch out for repeats. Okay, if you receive a $0 citation, a $0 citation normally means this is one they're going to throw out pretty quick because they didn't care enough necessarily to put a dollar amount by it. So it means they either don't have enough evidence or it's not important enough for them. So if they throw out a $0 citation, thanks, but I'm more concerned about the fall protection ones. That's what you need to be concerned about, okay? Obviously, citations come first, dollars come second. They will reduce fines. We've seen, a certain percentage that will be reduced at the informal level. After you get done with the informal conference, keep in mind there's some other things that you can include in your stipulation, okay? Stipulation is like a settlement agreement. There's some magic language that you can put in there that will assist you in fighting off bad guy lawyers if it's an injury type case. There are, payment terms that you can come up with. There's a variety of ways to negotiate it. You just have to know how far to push it and what you can do and what you can't do. If you walk out of that informal conference and it doesn't go your way, what do you do? Well, what you do is you remember your contest date and you circle back and you do the analysis on it. Is it worth taking it up to the next level? Okay. And it depends. It depends. We had one a while back. It was a roofing contractor that did nothing but federal work. They had a willful citation, and they turned to me and they said, Trent, we cannot have a willful violation. We will never get another federal job. Yeah, I don't care what it takes. We got to fight it. I was like, all right, brother, let's go. Okay, and we ended up getting it reduced. What will happen once you end up in a situation where you actually contest the citation within your 15 days, the notice of contest is usually a letter that says, hey, I contest everything about this. I contest the fines. I can test the citations themselves. I can test the penalty amount. I can test this manila envelope that I don't understand why you're sending it to me. Everything, I'm being facetious, but you get what I'm saying. You gotta contest the dollar amount, the citation, everything about it. You send that, make sure that you send it certified mail return receipt requested FedEx, email, send it 5 different ways so that everybody gets it within the time frame. I always send it via email as well, just to make sure. Once it's submitted, it goes into active administrative litigation. It takes usually a couple of weeks, sometimes a little bit later if they're not on the ball, and you get a complaint, again, in another manila envelope, okay? You will have to answer that complaint just like you would answer a civil complaint. When you answer that complaint, you want to assert your affirmative defenses. Not to use legal speak, I've tried to keep it business-wise, but affirmative defenses are the defenses that you would put forth that would say to OSHA that these citations are not valid. Okay, makes sense? So I want to touch on that a little bit. We've got 5 minutes left. I want to hit on the key things about affirmative defenses. There are a variety of defenses that you may not realize you have to an OSHA citation. Okay, just because somebody didn't have a harness on or didn't do what they were supposed to on the job doesn't necessarily mean that you should be cited and fined. Okay. Some of the stuff that we look for is duplicative citations. A lot of times we see 2 citations that are exactly the same thing that can be cured from the same form of abatement, okay? If it can be cured by the same form of abatement, that's double dipping, okay? And we catch a lot of assistant area directors off guard with that defense because they're like, oh, okay, well, I didn't think about that. So by the time the Department of Labor lawyers get it, they're looking at it, they're like, yeah, that's duplicative. Okay, good faith compliance. Okay, keep in mind that if you've taken steps to remedy the situation, if you consider what's going on, they will take that into account, that you acted in good faith, you attempted to comply, and they will look at that. Okay, they'll look at your past history. If you've got a horrendous history of OSHA violations, then could be a problem. If you had a past inspection which resulted in no violations, that could be good. If you've got a history of 20 inspections with no violations, they're going to look at that and they're going to see that that's going to help show that this may be an aberration. Okay. Severity and exposure. They're going to want to see, how long did the safety violation last and how many employees were exposed to it. If you've got a commercial roof with a 10-man crew on there and there's no safety monitor for 5 hours, that's a lot worse than a guy unhooking to get to a ladder that takes 3 seconds. Okay, the potential for severity is the same. You could still result in a fall, but the exposure is less, and that's something that they consider. Unpreventable employee misconduct. Okay, this is important. Unpreventable employee misconduct. OSHA would love to, the Department of Labor lawyers would love to tell you that this is impossible to prove. It is not. Okay. What you need to do in order to have a good unpreventable employee misconduct defense is exactly what I've been talking about for the last hour, okay, minus the technical difficulties I had. The first is program, okay, your safety manual. You want to have a very strong safety manual, okay? You want to make sure that you are keeping up-to-date OSHA logs. Be an advocate in your OSHA logs. Don't put too much information on there. Don't say guy fell off the roof because I failed to give him safety equipment. Just say, how he was injured. It was a fall. He injured his knee, whatever it might be. Okay. Same when you're reporting to workers' comp or reporting to anything you put in writing anywhere is discoverable unless it's to your attorney. Make sure that you've got the evidence that the program has been conveyed to your employees. How do you do that? Well, we talked about sign-off sheets. We talked about toolbox talks. We talked about ongoing training. Okay, engage in a system of audits designed to identify non-compliant employees. Okay, you want to actively have a system in place, processes and procedures to identify non-compliance, correct it, and what did I say before? Retrain, okay? And finally, you want disciplinary written records showing discipline for safety violations, write-ups. You know, even if it's a slap on a wrist, it's evidence, okay? Termination, suspensions. If you terminate somebody for a safety violation, make sure that HR, make sure that somebody is reporting that and that you're keeping that in a separate safety file. Again, it's about being able to put your hands on stuff quickly, okay? Other defenses that I'll mention quickly, I know we're running out of time. If you get a willful violation, and you know, for the longest time, even under the current administration, which is less OSHA friendly from a top perspective, from the deep state perspective, I still see a ton of willful violations. So when you get a willful violation, think about these as potential defenses, okay? In order to have a willful violation, management has to have knowledge of non-compliance. You have to have knowledge of the standard. You have to intentionally disregard it, and there has to be exposure to harm, okay? If you can show that you didn't intentionally disregard it or that you didn't have knowledge, keep in mind that that knowledge component can be imputed through your supervisory personnel. That's why supervisors are entitled to counsel. Make sense? It's all coming full circle. But there are a lot of defenses to willful. They're difficult to prove. They're also one of the highest level fines you will get, and there's the most at stake. Okay, defenses to repeat, substantial similarity. Is the fine that you're getting, is the citation you're getting cited for the same as one that you got cited for before? And the last thing to remember is that if you are a smaller contractor, remember there is the Equal Access to Justice Act. It does have the ability to get you attorney's fees. It's applicable when OSHA actions are not substantially justified, okay? It is difficult to get, very, very, very difficult to get, but it is worth asserting, okay? It does at least give you the potential. I'd love to see some changes here because it's difficult to obtain. I'm going to turn it over to questions now. John, if we still have time, I don't know if we do or not, but if anybody has any questions, please let me know.
Yeah, thanks, Trent. That was a great presentation. We don't have any questions. Oh, here comes one right now, actually. It's regarding the recording. The recording, so it takes a little time to download the recording after the fact, but it'll go up on the web probably within the next, but by the end of the week. So I'll send out the link to everybody who registered for the webinar so that you can all have a look, you know, whenever you have a moment.
Great.
Give everyone a second for any more questions. Perfect. Well, thanks again, Trent. I think everyone was, was really helped out by this information. So hopefully when we get the recording out there, everyone can take a pass back through, and I'm sure Trent would be happy for you to reach out to him and follow up if you have any, company specific questions.
Sure. Thank you, John, and thank you guys for listening. Obviously, I'm very passionate about OSHA defense and the industry, so feel free to reach out if you have any questions. It's been a pleasure.
Thanks, everyone. Have a good afternoon.